Hello and welcome to our webinar on tackling data protection concerns in the realm of evolving fintech industry in India. On behalf of Hammurabi and Solomon Partners, I would like to extend a warm welcome to each one of you. I am Kushagra Verma, Associate at Hammurabi and Solomon Partners, and today I am your moderator along with our distinguished speakers, including retired Colonel Deepak Joshi, Mr. Rahul Jain, Mr. Debasish Roychowdhury, Mr. Rohit Jolly, Mr. Mitesh Pawaskar, and Mr. Amit Verma, whom I would be introducing in detail very shortly. But before that, let us delve into the webinar agenda. We are all aware that the DPDP Act is India's first comprehensive national legislation on data protection. This legislation is supposed to dramatically reshape how businesses handle personal data. So the agenda for this webinar is to explore the key aspects of this act and what it means for the ever-evolving fintech industry in our country. This session is primarily going to revolve around the methods of the systems which can be implemented by the fintech companies to achieve privacy by design. For the audiences watching this webinar, if you have any questions, please do not put your questions along with your email on the chat box provided on the YouTube, and you shall be receiving answers through email shortly. Before we proceed with the sessions, kindly allow me a few minutes to introduce our firm, Hammurabi and Solomon Partners. Our firm, Hammurabi and Solomon Partners, is a leading full-service law firm established in 2001. Over the years, our firm has built a reputation for providing comprehensive legal services across a wide spectrum of practice areas. Our core areas of expertise include corporate advisory, mergers and acquisitions, data protection, compliance, litigation, arbitration, insolvency and bankruptcy, public policy, and real estate, among other practice fields. We take pride in our team of over 100 professionals, including 16 plus experienced partners who bring diverse legal expertise to the table. Our team operates across multiple regions in India, including Delhi, Mumbai, Bangalore, Jharkhand, and Ahmedabad, offering tailored solutions to meet the unique needs of our clients. With a commitment to excellence and a focus on client success, our firm strives to be at the forefront of legal innovation and provide high-quality legal counsel and representation in complex legal matters. With this, let me introduce the speakers for today. We have Mr. Mitesh Pawaskar. He is a Director Technology and Information Security Expert at Systech Technocraft Services Limited, Private Limited, which is a cybersecurity and data protection distributor. Then we have Mr. Debasish Roychowdhury, who is a General Counsel and Head Legal Compliance and Secretarial at InSolutions Global Limited. We have retired Colonel Deepak Joshi, who is a cybersecurity and data privacy professional and makes regular contribution for cybersecurity awareness. He is a fellow in privacy from International Association of Privacy Professionals and holds numerous certifications in cybersecurity and data privacy. Then we have Mr. Rahul Jain. Mr. Jain is a partner in the General Corporate Data Protection and TMT practice at Hammurabi and Solomon Partners. We have Mr. Rohit Jolly, who is an associate partner in the Data Protection and Dispute Resolution practice at Hammurabi and Solomon Partners. And we have Mr. Amit Verma. He is a partner designate in the General Corporate M&A and Data Protection practice at Hammurabi and Solomon Partners. That being said, let us start with our discussion. So since we've seen that the Digital Personal Data Protection Act has drawn significant inspiration from the GDPR, Mr. Pawaskar, I would like to ask you, could you start by highlighting some of the key similarities between the two frameworks, especially in terms of how they regulate data privacy in the fintech sector? And are there any unique aspects of the DPDP Act that set it apart from the GDPR? Mr. Mitesh?
Yeah, I think my mic was not unmuted. I hope you guys able to hear me now.
No worries.
So thanks for this opportunity. This is a very important initiative, and many such initiatives need to be taken place to improve the awareness on this subject across the industry. I'm glad to be here. So to answer your question, there are a few similarities and there are some differentiations. We must understand, number one, GDPR is a much mature law or much mature act because it has been introduced for so many years now, and it is taken into effect for so many years now. DPDPA is still nascent in its stages, and as it progresses, as it gets implemented, as it gets notified, and so on and so forth, we would get better understanding of it as well. So that's one big difference between the two. The key similarities between GDPR and DPDPA is that there are certain aspects which are very common, like consent. One example of that is consent. That a consent must freely be provided by the subject or the principal. Legal obligations, there are some similarities with regards to legal obligations and vital interest. Data processing agreements, data protection impact assessments need to be taken place. The fact that protection officer needs to be there in every organization or an entity. Representatives are identified. Elements of data fiduciary, data principle, they are clearly defined, right? So those are some of the and of course the right to withdraw consent, the rights that data principals have with them. So those are some of the key similarities. When it comes to differences, one thing is DPDP is still new, so it will evolve. But cross-border transfers, there are some elements that have been not clearly defined, but there are still some elements that need to be defined. The fact that data, where it can reside, the focus on how data needs to be residing within Indian geography, borders. Data breach notifications, how there is no limit per se that has been set. Every data breach needs to be notified to the DPM. So significant data fiduciaries. So these are some of the entities that have been defined. Indian government has the power to classify significant data to fiduciaries. So those are some of the key differences. Over to you, Kushagra.
Thank you, Mr. Pawaskar. Your explanation on the similarities and differences with the GDPR brings to the forefront the importance of ensuring data security in the evolving fintech space. With the rise of digital financial services and the increasing volume of sensitive data being handled, cybersecurity becomes paramount. As we know, the DPDP Act emphasizes the need for rigorous security measures. So, following upon the similarities and differences between the DPDP Act and GDPR, one of the critical aspects of the Act is how it tackles cybersecurity, especially as fintech companies are rapidly evolving. So, my question to Mr. Jolly is, from a cybersecurity perspective, how does the DPDP Act ensure that fintech companies stay ahead of emerging threats?
Thank you, Kushag, for the question. So, coming to your question, we have to differentiate between two types of companies. One is the fintech companies that are rapidly evolving, and the traditional financial setups like banks and other institutions. So, coming to the first part, fintech companies are fast growing and hence require enhanced security measures to counter such risk and challenges. So we need to assess the risk and challenges that are being faced by the fintech companies may be different from the challenges that are being faced by the traditional financial setups. For for a fintech company or a startup, if I may say, or these payment aggregator services, they are heavily reliant on this application programming interface for data exchange creation. So for that, with these API softwares and the banking apps, the threat is much more than for a technical traditional banking institution, because these apps are targeted due to weaker device security and vulnerabilities in app developments. And with the technical innovations, AI developments, we face threats like phishing attacks, data breaches, insider threats, malware, and ransomware. Hence, a comprehensive act was the need of the hour. And with this DPDP Act, we can just streamline between how these companies can streamline how to go about implementing them in their companies. However, there are no distinct guidelines that separate these fintech companies and from the other companies. The DPDP Act generally provides all these guidelines. However, coming to the practical side of it, both these types of companies, say fintech and traditional banking companies, both are likely to be classified as significant data fiduciary under the DPDP Act, because they are likely to, due to the volume and the sensitivity of the data. So first and foremost, that the compliance that they would need to be done to counter the cyber attacks would be appointment of DPO, that is the requirement data auditor, and regular assessment and audits that need to be carried out. For the fintech companies, they have to work out a way that these compliances are implemented by privacy of by design, and integrating these security measures at the stage of software development itself, rather than taking a reactive measure. With the traditional banking institutions, it might be a little different because they face different challenges, and integration of these safeguards might take a little time. Because, however, with the evolvement of these technological companies, they need to be hands-on with the privacy by design. Secondary, data minimization and limitation of data is very important. As per the DPDP Act, also you can only collect the data that is required to be assessed. Any additional data need not be asked for, and in case they had to be, clear consent has to be required. That is a given. Especially in the times of adoption of AI and blockchain, these data minimization and limitation plays an very important aspect for these fintech companies. For the traditional institutions, they may adopt these technologies at a different pace and scale, leading to various impacts because of the size and the not they have a lot of non-digital data as well. And with the present act prescribing such significant penalties, which may also act as a deterrent for these, say, startups or fintech companies, this will make sure that to comply with the act, they will invest in a robust security network. And last but not the least, since all these data fiduciaries must have airtight agreements with data processors and make sure they are back-to-back liabilities, because they will need these data processor to handle a large and sensitive amount of data. So in case of any data breach, these back-to-back liabilities are must, and that will ensure and a proper implementation of the DPDP Act and protection against the cyber attacks. Back to you, Kushal.
Right, sir. Your take on the fact that banking companies and fintech companies should be considered within the ambit of significant data fiduciaries was very interesting, and it was logical, taking into consideration the kind of sensitive personal data it has been handling and the volume of data it has been handling. So, continuing from this, one of the most critical aspects of the DPDP Act is its approach to automated decision-making processes, such as AI-driven credit scoring. So, I would like to ask this question from Colonel Deepak Joshi, that since these AI-driven systems handle sensitive personal data, what role does the DPDP Act play in ensuring that fintech companies build systems that are not only secure, but also fair and transparent? And how do you see fintech companies addressing the risks of bias and discrimination in such AI-driven processes? Mr. Joshi,
Thank
please.
you, Kushagra sir.
Thank you.
So the thing is that first that AI, as we understand it, there is no standard definition of AI as on date. Everybody is defining AI in their own realm of affairs. When we talk of AI in a very simplified term, AI is like a small child who behaves in a manner in which you train it to be. So the problem which lies there is in training. So when we talk about use of AI in credit scoring, there is a situation wherein the data, if trained on a specific set of people from a particular region in India, there are 28 states, the demography changes every 20, 40 kilometers, the food habits change, the language, some accent changes, and so on. So in case we don't train the models well, what we would see is a bias. We have had cases in past wherein big organizations, they had issues in their AI models and a particular gender was discriminated for promotions or recruitment. There were cases, and I'll say that in BFSI sector also, there can be a situation, now that we are speaking of FinTech, there may be a situation that a particular religion, if used, and people from a particular region or a pin code are used, and the set of people which are taken up, they are defaulters of a particular region or say religion, the entire profiling would go haywire, and that particular religion people, that particular region's people may not get any kind of loans, may not get to participate in government schemes and so on. So there lies the actual thing, that the training of the data models, the algorithms which are there, they would work fine provided the training data which is there, that is an all exclusive, covering all age groups, covering all religions, covering all people from all states, and then we would come to a situation. Otherwise there may be a situation that there may be a discrimination, which is very likely in case we don't tackle it at this stage. Now when coming to AI, it has its own advantages and disadvantages, and if done properly, the advantages are much more, especially the kind of the quantum of data which gets processed. Manually processing that kind of data is also subject to bias. In case suppose I am doing it, I can also have a bias towards a particular region, religion, gender, age, profession, and I may introduce as a human being also, and so can AI. So we have to be very, very cautious there in training our AI models. And as we do in GDPR, there is a term called DPIA, and any thing which is subject to AI profiling, there is a specific consent and a privacy notice, which is given that you are being subjected, or you will be subjected to AI based profiling. That is a separate explicit thing which is over and above any other consent which is there. And there is a facility, or I'll say the option with the residents there in EU, that they can opt out of that particular thing, or rather they have to opt in EU's case, in GDPR's case. So that kind of a thing we need to introduce here also. And when we talk about introducing certain things, then things like data minimization, that should be there, that the data which we are using for credit scoring, that shouldn't be taken up from here and there. That should be genuine data, and when we train our AI model on that data, then those people also need to be informed whose data is being taken up for training, because otherwise they are not aware only that their data is going in for AI model training. The quality of the data which is being used, the requirement with respect to regular accuracy of data, explaining to your data subjects or data principals as we call it, keeping our data and other repositories ready for inspection by, say, by DPB or a nominated agency, then the right to access and right to make modifications to that, all these are required, so that the people who are there, they have some kind of control over their profiling which is being done, because it affects them financially. It hampers their chances of getting into a relationship with the financial institute. So here we need to be cautious right from the time we adopt a AI model, because right from the time of adoption till we dispose of the data, there is a continuous requirement of keeping tab on that. Thank you so much.
Thank you so much, Colonel Joshi. And I completely agree with you that training of these AI models should be done at the very inception. And the data which has been acquired by the people from the data principals, they should also be provided with all the information as to how and why their data is being used. And thank you so much. Now, in the context of AI-based credit scoring, we know that fintech companies follow or implement certain technical mechanisms to avoid biased or discriminatory data processing. So, Mr. Verma, in your experience, what steps can fintech companies take to ensure compliance with the DPDP Act to ensure that the personal data of data principals remain protected? Over to
Thank you.
Mr. Verma.
Thank you, Kushagra, for having this opportunity to speak about this fintech in terms of DPDP compliances. In today's scenario, the recent rules provided by the DPDP rules, that is in draft mode, that specifically comes towards the fintech industry, in that is completely reliability of the rules are very in wider zone, but in practicability it's very you can say very limited to consideration, because there's numerous aspects needs to be adhered by this fintech industries. So in terms of that compliances they are considering, specifically toward the fintech industry is like the consent. The consent mechanism is the major concern for them. That is the primary thing that we are considering in aspect of the fintech industry, because fintech industry itself, you can say, considering all the aspects of each and individual, like they are taking the data from the data principle, but the explicit consent they need to define, that needs to be adhered here completely. Like if you need to define the purpose, like you'll use for the transactional purpose, plus in terms of the additional like credit rating agencies needs to be considered in other aspects of like you're using payment gateways. So all these purpose needs to be defined explicitly in the consent itself. So all these data fiduciaries come down in a one consent document. It's very less feasible for all the fintech industries. So aligning in that perspective is the one major concern from them, like handling the explicit consent. Another one point that I can speak in about that, it's a data minimization. As I mentioned, like there are numerous data fiduciary in the single transaction itself, having like initially if you provide the bank, then there's a payment gateway, then in respective further data storage, data processors, like cloud storage and all. These multiple parties in the same transaction, it needs to be adhere like how the data minimization, because every industries like in the finance, you can say the banking, for there's a limited timelines as per the banking laws, but in terms of the tech laws or the companies act, there's a defined different timelines, plus there's a RBI regulatory requirement for all the storing of data, including the payment gateways processing timelines also. So every laws have different perspective of storage of data. So in that way, the data minimization is also a very big deal for them to understand how they can consider in a streamline a single way, because this DPDP Act is not prevailing till date on the all applicable laws. It's like in addition to that. So government need to understand how we can in line with that perspective to make it streamlined for all the other regulatory aspects, considering like different types of industry in a single chain for fintech industry specifically. Another thing in terms of that, they are considering the data principles rights, because in fintech industry, usually this is driven by like the whatever the private entities or in other entities types nature, they will consider the type of nature, but majorly that is from private in nature, that is not government driven. So in that way, it's like if a private entity getting into that, so the concept of public at large and as per DPDP, the legitimate purpose or lawful purpose, it's easily not able to like, quantify that aspect, because private person is taking and private entities considering the whole data, and then they were able to justify the aspect of that they will use for legitimate purpose. So like if they are considering as an NBFC, if someone is the NUSC entity is taking the data from that perspective, then they will govern the aspect of next stages also, like how they will process, and then next step coming out from the and next you can the data fiduciary itself. So this is also a bigger problem for the fintech. You need to streamline in all the aspects is also a bigger problem from them. So this is the major 3 pointers in terms of like fintechs for the data needs to be adhered. Thanks Kushagra for that.
Thank you so much, Mr. Verma. You've raised very important points like consent mechanism, data minimization, and legitimate purpose, which inherently also reflect the rights of data principles. Now, considering the growing prevalence of cross-border transactions and payments in the fintech space, especially with the recent RBI approval for payment aggregators, Mr. Jolly, how does the DPDP Act ensure the protection of personal data in these cross-border transactions? And what safeguards are in place for individuals using these platforms as opposed to the more traditional financial systems?
Thank you, Kushag. First of all, this coming to the RBI approval of including payment aggregator to the realm of cross-border data transfer. First of all, it increases the opportunities, but also the increase of personal data across national borders also increases the risk. Hence, a legislative commerce law like a DPDP Act is absolutely essential, because the amount of data that will be transferred through this payment aggregator services now acting as in cross-border transactions, there is the need. Before I highlight how DPDP will help in ensuring that these transactions are governed by the Act, first of all, I would like to highlight the RBI circular that had come out in, I think, October 2023. That had basically that deals with the regulations governing the authorization of payment aggregators to facilitate cross-border transactions. A central aspect of this regulatory update is direct regulation of all entities that facilitate these cross-border transactions. These entities are now being classified and referred to as payment aggregator cross-border, PACB too. So these guidelines mandate the entities who are non-banking entities to take authorization, and these were required to authorized before 30th of April last year. In any case, in any new banking, non-banking entity who wants to operate as PSCBs, first of all needs to take the authorization. So this is a first step compliance for a PSCB to operate to be compliant with the RBI guideline. There are other RBI guidelines also, but we'll talk about them later. Coming to the obligations of a payment aggregator as a data fiduciary. So when it comes to cross-border data transfer, the Act has emphasized that there are certain stricter consent mechanism, security breach obligations that are cast upon the data fiduciary. So these will automatically be cast on the payment aggregator, being in the fintech sector, to comply with those regulations. So a payment aggregator as a data fiduciary, the act, the consent has to be in unambiguous language. The clear notice has to be given. DP rights have to be explained. Grievance redressal. Data has to be processed lawfully. Data accuracy. As a significant data fiduciary, reasonable safeguards has to be ensured. Data has to be raised when asked for. In case of though it might not be applicable, but data relating to children, parent consent is required, withdrawal of consent. So all these safeguards that have been given under the DPDP Act and as the guidelines that a data fiduciary has to operate in, it gets more on a payment aggregator to be abiding by these guidelines. So further, the Act provides for principal rights. For example, the right to correction and erasure wherever applicable. So when a payment aggregator acting as a data fiduciary, he has to maintain that all the rights have been safeguarded and nothing, in case of any breach or anything, data processor is informed and relevant steps have been taken to ensure the implementation. Further, coming to the practical aspects, besides what all the Act has prescribed, for a fintech company to ensure that the data is protected in cross-border transfer, some practical implementations would be strong encryption of data when it comes to your card details, installed systems to detect unusual activities in case of any higher amount transaction that can be seen. So it has to install system that emergency is raised or something on those lines. Stricter rules for employees while processing of data, and last but not the least, training of employees will be the most crucial when it comes to fintech companies to protect the data. Now coming back, when I said that RBI has some additional guidelines as well. So for in data localization is one of the things that RBI focuses on. However, there are another compliances which are known as PCI DSS compliance. So these standards are set for security standards that are designed to ensure that card payments and online transactions remain protected or theft proof. It details certain 12 key requirements. I can't recall everything, but putting up firewall, enabling secure password protection, and a couple of other guidelines that make sure that in before the DPDP Act, RBI has also ensure that the personal data in these cross-border transactions are protected when a non-banking entity is also involved in PSCB activities. Last, but we will get to know more when the act is implemented, which is happening sooner than later. But DP Act ensures data safety and security from the looks of it. But however, payment aggregators will have to have a robust network and make a security safeguard to ensure with that data is protected in cross-border transactions. That is all from my side.
Thank you, Mr. Jolly. It was a wonderful explanation. And indeed, it is a topic of concern, especially as FinTech expands globally. There are going to be stricter implementation of the DPDP obligations which have been imposed on data processors and data fiduciaries. So my question to Mr. Jain is, going back to the DPDP Act's principles, what are some of the key challenges that sandbox entities face in complying with these regulations? And how can these entities balance innovation with adherence to stringent data protection laws?
Yeah, thanks, Kushagra. And thank Hammurabi and Solomon partners to be there on this stage with esteemed guests, Mr. Deepak Joshi, Mr. Debasish, Mr. Mitesh. So Kushagra, with respect to sandboxes, so I believe, always we say that technology is ahead and then law is trying to catch technology. But in this scenario, if you see what RBI has did, they have created sandbox entities so that how we can cater the new age technology vis-a-vis financial technology, financial services. So here they have given a 6 months duration. This particular sandbox regulation came in 2019, and they are providing that entities who are doing revolutionary fintech innovations, they must be given some time so that they can test on this technology and they can easily adhere to the compliance regulation of RBI with respect to, say, voice based payments, or as told by Rohit, PACB, or with respect to MSME lending or financial frauds, or now we are seeing central bank for digital currency. So all these are innovations, and as soon as we have the sandbox regulation, this allows entity to just adhere to the norms as early as possible, because at some point of time we see that it could be a totally new technology which requires some interference from RBI so that it can be adopted in a very compliant manner. Having said that, so I think in terms of purpose limitation constants which are there under section 6 of DPDP Act, we understand that of course, when we are trying to get the notice with respect to consent of the customer, we write it in a, because that notice has to be unambiguous. But at the same time, it also has to be generic in terms of doing certain things from it, in terms of, say, credit rating or credit related and stuff from the customer, if that data is being, say, used for fraud detection as well. So how we need to identify the notice language so that it can solve various purposes, considering the fact that it should not be ambiguous at the same time. Considering that these entities should also have security protocols. So, talking about AES protocols or NTLS or multi-factor authentication, and then we also say in a very candid manner, Tom, which are technical and organizational measures. So we have physical measures like role-based access control. We are having intrusion detection and preventive systems. We have data masking. We have security audits in terms of VAPTs. So I think all those security measures need to be adopted. But again, having said that, these are a game of a big budget, wherein these entities must not be having at that budget at that point of time, but they need to identify how they can be done on the contract basis by entities who are having that kind of facilities. um, uh, Having said that, these entities should also have to take care of their KYC master direction as given by RBI. And of course, everything comes on the budgetary constraints. So, they need to identify how they need to have, some budget for these new kind of technologies, or, training programs, or hiring some compliances personnel to do compliances with respect to these new sandbox entities. Of course, resource limitation is still there, and lack of clear guidance, we can say, with respect to sandbox frameworks, because we are talking about new technologies which needs to be catered and which needs to be embedded in the compliance framework or of RBI as early as possible. So of course there are some limitations as well with respect to sandbox entities.
Yes, definitely, Mr. Jain. Uh, Building upon the challenges as mentioned by you, which have been faced by the sandbox entities, I would like to ask Colonel Joshi that since fintech companies operating in this space often have to navigate complex compliance requirements also, while still pushing the envelope in terms of innovation, how can these companies ensure that they are not only compliant with the DPDP Act, but are also effectively able to manage the costs associated with implementing robust data protection measures? Over to you, Colonel Joshi. Colonel Joshi, I think you are on mute.
So, sir, sorry about that. I would add on that the way the previous speaker has put, there is a requirement of striking a balance between the way the budgetary is placed in an organization vis-a-vis the kind of compliance requirement which is there. So when we talk about, I think there are numerous solutions which are available in the market now, who guarantee you that right from consent management stage till the disposal stage, they would be doing it end to end. There are all kind of solutions from various budgets ranging from few lakh to few crores, from small people to big, but then they are not sector specific. And when we talk about a particular sector, there is a peculiarity with every sector, every organization, the way data is collected, the way it is stored, and the way the particular regulator sees it, the kind of compliance. Some sectors are completely, I'll say, loosely regulated, and then there are certain sectors which are heavily regulated, in which there are strict penalties. There may be a situation that you may be told to close down your business. So in order to meet that, as we have already seen that the various guidelines which are there with respect to the purpose, with respect to the way the data minimization is to be done, the accuracy aspect of it, transparency, notices which are to be given, all that is there. Besides that, the grievance redressal mechanism which you have to have and also demonstrate at the same time. So taken all that together, there is a requirement to have a, I'll say, proactive approach towards it, because many people now also are sitting on the fence and observing that which side it is going to turn. So I think the time to act is now. And when we are having this particular seminar which is specific to fintech, there are no excuses which are there, and so hence we need to actually adopt it fast, make sure that we are compliant and also demonstrate it, and then also at the same time project our compliances and our proactive strategies as a revenue center to our clients. We need to have them more confidence on us that yes, these are the organizations. Suppose if we say talk about a particular firm which is having much more robust compliance audit, various certifications which are there with them, obviously they have better confidence of prospective customers that their data is being handled properly and much more safer than when compared to other rivals in the market. So all of that taken together would definitely help that we have an outlook towards compliance, and we have to seek those to see those compliances as a requirement which is there to help us navigate the situations of data breaches, of cybersecurity incidents, and then use that and leverage them to our advantage to have a better standing in the fintech industry. So thank you so much.
Thank you, Colonel Joshi. It was very insightful. Now, continuing from where Mr. Jolly had left in the question regarding cross-border transactions, I would like to ask Mr. Jain, like as to how should fintech companies handle the detention of sensitive data? like KYC documents or any other kind of document which is really sensitive when considering a data principle? And what measures should they implement to ensure that data is securely stored and deleted when no longer necessary? Talking about the talking about the legitimate purpose of using such personal data. Over to you, Mr. Jain.
Yeah, thanks, Kushagra. So I think data retention and data deletion have three aspects. One with respect to timelines, and they are part of same coin, because the time you will retain the data, you need to have a specified purpose why you are retaining it, and then when you have deleted it, how you have deleted it, and you have the way with which you are deleting it. Retention must have the objective that why we are retaining it, because data, when it is stored, it has various usage. You do data analytics, you do a lot of stuff. So if you talk about certain sections, if you see section 12, section 6(1), it is talking about consent has to be specific. So it means that data has to be for the specified purpose. Considering now RBI mandate, of course, 5+ year are the data timeline within which data has to be stored. But of course, when we having different laws in place, so the timeline could go above that time period or could go below that time period. But if you talk about, say, the act itself, under rules, they are also mentioning that the data with respect to logs and all can be stored up till 12 months. So I think what we need to do, we need to retain the data for the maximum time period, and it can be, then it will be complying with all the requirements. Having said that, I must say that we should also identify that what kind of data uh, retention formats we are having, or say database management systems we are having. This could be relational databases like MySQL or Oracle, which are having the purpose of efficient querying and retrieval. This could be a NoSQL database like MongoDB or Cassandra, which have scalability and flexibility. This could be database warehouses as given by Google or Amazon's, like Redshift, Big Blurry, and Snowflakes, which helps in faster analytics and retrievability. Because when you are having a data, you need to understand how to get maximum out of it. And then finally, with respect to backup solutions, which we are having in the form of VM or Acronis, which helps in the making data available and retain the integrity of data. So when you are doing data retention, you need to do it from those purpose which allows the maximize utilization of data, and it makes the retention beneficial to the data fiduciaries. Secondly, when you are talking about data deletion, so technically, again, you need to identify how you have deleted the data. So you need to have these erasure tools like dban or blanco. You need to have cryptographic erasures wherein you are deleting the encryption. See that the data cannot be accessible. You may have digital shredders. You can have verification audits. You can have log and monitor analysis wherein log of deletion activities needs to be made the part of the compliance program, because you need to show somewhere in the documentation part or in physical mode that okay, that's how I have deleted the data, because that is very important. Because if there is any kind of pilferage happens and authorities comes behind you, you need to show in the form of evidence that the data has been deleted, and we have this proof of evidence as a deletion of data. So I think timelines are very important with respect to deletion and retention. The way with which you are using the technology in terms of data retention and how the data deletion is being done, and finally in terms of identifying that for how much time period this data has to be retained as per the schedule 3 of the proposed rules, wherein they have given 3 years timeline to save the data of e-commerce entities and other social media intermediaries.
Thanks a lot, Mr. Jain. Indeed, I especially agree with your point of that data, personal data, should be retained for as long as possible, so that the data fiduciaries are able to comply with most of the compliances which have been provided under the Act. Now, coming to Mr. Verma, with the ongoing complexity surrounding cross-border data flows, how does the DPDP Act strike a balance between the need for localization and the demand for seamless data transfer in fintech? How should companies ensure compliance with these regulations in light of global data sharing?
Thank you, Kushagra. In terms of the cross-border data sharing, there is like initially data DPDP Act, that is we consider it. Before that, the data has been shared by India to the other, you can say, regions or the countries on the basis of the normal IT Act itself. So there is no major restrictions at that time, but there are some restrictions from some specific laws, like for the RBI have some kind of regulatory aspects to sharing the data for payment purpose, like storing the data for payment purpose in India. It's a RBI guidelines. It's specifically derived in that way. However, in other aspects, if like say other laws that initially accept then RBI, there is no other specific. The respective countries have their laws needs to be adhered for while we sharing the data with them. In terms of the DPDP Act, from where we concern is that the data sharing is with the other cross-boarding. Basically, the cross-boarding sharing data is allowed, but there is some kind of like limitations in terms of the requirement of the specific industry. It's no completely not bad, but like if you're using for the payment perspective, then it needs to be stored. Like storing of data, it's also allowed outside India, but there are some kind of conditions that is been specified, but it's very reasonable conditions in terms of the data storage outside India also. But as of now, like GDPR having that if you're sharing the data, they need to process the DPAs. But in India, that is not specific condition in terms of the sharing the data, because the processors are allowed to share the data. However, if any industry specific laws that needs to be adhered, this is the one major point, like how the data has been shared and how the regulatory aspect is there. Apart from that, cross-border is basically the way in that how the data needs to be safeguarded. One is like processing, one is in like storage. So in that way, if someone is storing the data, and DPDP Act is completely governed the Indian perspective. So how if someone is sharing the data outside the perspective of the DPDP Act, then security measures that is been considered by the whomsoever the data fiduciary or the data processor, we need to consider multi-jurisdiction laws. In that way, one of them is like India is for DPDP, then GDPR for, you can say, for other UK European regions. Then another aspect of it, that US have separate laws in that norms for specifically for data sharing. So there are the whomsoever the global presence in terms of sharing the data, they had to adhere the multiple consideration of all the laws. So if one of the person is considering like any platform is providing services for fintech, so in that way they will consider like, once I will considering as of now, like child is specifically in India is specific defined in different year of age, and but in US it's different. So in terms of that understanding, we need to maintain a global understanding also while we sharing the data, who become a child and who become an adult, and then their specific consent needs to be adhered. Like in India, it's the guardian needs to be just considering the consent, but in US, it's considering that how the data will be reviewed by the parents, and then they need to provide the consent. So that globalization is the major factor while considering the cross-border transactions or including the cross-border data sharing also. Another thing is like the platforms over that cross borders using their long numerous datas. For illustration, like if we are considering as of now the new generation considering global connect, like payments is a new requirement for like UPI is considering in India, but we are planning as a like country specific, the data needs to be shared at global level, then the regulators and all will adhere that perspective that how we can utilize their own softwares to provide the global support. If they considering like UPI at global level, then all the aspects of the regulatory will be considering DPDPA in not in one India, it needs to be adhered with the other regions also from where they're getting into that domain. So these kind of considerations while cross-border data needs to be adhered. Like data principal consent is always that DPDP is little limited to India, but when we are considering the rules that is been proposed, that is also little limited. What we expecting is very higher understanding in terms of data needs to be shared cross border, because if Indian penalty is limited, if the other region UK and US penalties and higher, so how we derive at that? Like, it's not an Indian perspective, that because cause of action needs to be adhered in terms of where the data has been lost and how the fiduciaries needs to be adhered in that of understanding. So all the way the channel, the chain that we create, it's a multiple impact over the whole transactions. So the regulatory aspect plus the sharing of the data plus the law itself needs to be enhanced in that way that understanding will be carved out, not from India, from the global applicability of laws also. That is the major overview for the cross-border transfer of data that I can share. Back to you, Kushagar.
Thank you so much, Mr. Verma. This brings us to the broader challenges of data transfers. So, Mr. Roychowdhury, considering the nature of fintech operations that often involve both data fiduciaries and data processors, how should fintech companies manage these dual roles under the DPDP Act to ensure that they are meeting both regulatory and operational obligations?
Thank you, Kushagra. So I think on a Saturday evening, we all are meeting over here. It's a testament to the fact that how important this particular topic is. And I think we need to have more such confabulations going forward to have a clear understanding about the law, because as we see, we have an act in one hand and we have a draft rule which is going to be kind of made effective, and then probably we'll have some leeway for the organizations to kind of come into the perspective. So anyways, thank you very much for this question. I think it's a very important question actually. So my first thing for me is that before we come to the data fiduciary and data processor part, since I come from a fintech organization, the most important thing for me is to understand what are the data mappings, what we are doing. So what is the inflow of data and what is the data which is kind of going out from our organization? Because that is the first kind of a checkpoint or kind of a mechanism where we can identify to do in our organization while we are doing our impact assessment for DPDP. The second thing, when we have identified that we are a data fiduciary, because most of the organization, I think 100% of the organizations anyway are data fiduciary, because the most important thing when you see, when you handle vendors, when you handle employees, and when you have in-house data, so obviously you are carrying a lot of information and a lot of data, which basically makes you a fiduciary. So classic case being like if you have employees data, so basically you kind of outsource it to third parties for data background verifications, or you have the data from the people or the prospective employees and all. So by virtue of having those data, you become data fiduciary. So obviously, whenever you are taking those data from the prospective employees, who are the data principals for that matter, so you need to have the consent, the specificity of the purpose, the minimization thing, and the legitimate use, and all these things kicked in. I think most of our eminent speakers have already spoken about it. So that kicks in, so that there's no kind of issue in that. The real challenge comes like when you take that data and suppose you hire some of the employees, that's fine. But when some of the employees couldn't go through, so what are you doing with those data? So are you kind of you are doing all those purgings, or how you are kind of taking a balanced approach in terms of handling those data? So that is from data fiduciary perspective that becomes extremely important. And why we talk about data fiduciaries is because the penalty is mainly on the data fiduciaries. When you talk about 250 crores, 300 crores on the data fiduciaries only. So that's the first aspect. The second aspect, obviously, when you come on with respect to the part of, the data processors. Now, for us, it becomes extremely important how we kind of safeguard ourselves, or what kind of guardrails we provide for the organization when we become data processors. The classic case being like most of our clients are either banks or financial institutions and all. And most of the time we enter into MSAs and all with those service recipients actually. So we call them as service recipients for that matter. Now, I'm talking from fintech, specifically from the digital or payment industry. It might be for lending institutions or for NBFCs, or others might be a little here and there. But I think I'm talking basically on behalf of everyone. So when you have service recipients actually, so your MSA should be very crystal clear in terms of whether you are defining those service recipients as data fiduciaries or not. Because in most of the cases I found, like, they put on all those conditions to us saying like, you are having those data. So this is what you are processing and all. So the liability would be on you and all. And they are trying to kind of bind themselves to this contractual agreement. But as a processor, we need to see that they are also defining themselves as data fiduciaries through those MSs, because until otherwise that is done, we won't be able to make that counterclaim saying going ahead that you are the fiduciaries and we are the processors. So the question of having they taking the data from their data principles, that becomes also extremely important, because if they share those data to us and we are not kind of creating an embargo on ourselves saying like those data has come through those service recipients, we would be in a soup, because in that case the authorities would come and ask us whether you have taken all those consent notifications, previously notice you have been issued or not. So those challenges are there. So from data processor, I think the most important aspect is that you should have a robust MSA which should contain all the specifications very clearly. What are the rights of data principals on behalf of the data service recipients? Whether the service recipients are kind of properly structuring it in those MSAs. And if there are issues, they need to come out very clearly. So that is more from the compliance part of the data fiduciaries and data processors. The next part is the risk management part. Because when you talk about, the first thing is the impact assessment you do, then the compliance part you handle. The risk assessment part is that whether you have a proper due diligence mechanism that you have done, you have undertaken in terms of identifying, in terms of those agreements or structuring your entire privacy matter. Whether you have a data protection officer or DPO in place, because in most of the significant data fiduciaries, you mandatorily need to appoint a DPO. And the third most important aspect is that how you are kind of protecting it yourself through the best use of risk management policies and all around DPDP. Like you should have a proper data privacy policy, consent management framework, privacy standards and all, so that you are safeguarding yourself from those challenges. Because if you see the prosecution part, obviously the law is yet to be made or made to be made effective from that perspective, because the rules are yet awaited. But the moment that will happen, so obviously the first challenge would be the prosecution part. And when the data protection board comes into picture, there'll be a lot of issues around that. And so you'll see a lot of cases. So risk management part becomes extremely important from that perspective. So if I want to summarize what I have just mentioned, so for both for data fiduciary and for data processors, I think the impact assessment, the compliance part and the risk management issue, and identifying that whether you are a data processor in certain cases and you are a data fiduciary in certain cases, that becomes extremely important. And the last piece I would like to add, what Amit and others have also alluded to, was with respect to, like, see, in most of the fintechs are guided by RBI. So specifically from payment industry, we have RBI guidelines and all in terms of how you do a PAPG, because we are PAPG and PPI certified. So we are license holders. So obviously we need to see how we are guided by RBI. So in terms of data localization and all, obviously RBI takes the center stage in terms of how we are managing those data, because RBI doesn't want that payment data and all those things should go outside of India. So in terms of investing on your cloud kind of structuring, or whether you are hosting in on-prem or wherever, so you need to be very significantly mindful of those facts, be the PCI DSS standards or be the VAPT things and vulnerability assessments and all. So I think it's an entire process what needs to be looked into. And as a general counsel, my role becomes extremely challenging at times, where I find that you have data here and there, like people are using it recklessly at times, and how you kind of create a structure around that, keeping all those four corners in mind. So I'll stop it here, but that is my initial thought on this entire piece.
Thank you so much, sir. That was very insightful. And it is a very interesting point that most of the fintech companies have to actually carry out both the roles, that of a data fiduciary and that of a data principal as well, processor. And to that effect, one area that's been growing rapidly is the use of chatbots in banking. So my question to both Mr. Pawaskar and Mr. Roychowdhury is that how can fintech companies ensure that these AI-powered tools like banking chatbots are secured against data privacy breaches? And what kind of measures can be taken under the DPDP Act to safeguard user data in this context when it comes to the AI-powered chatbots or any other AI-powered tool which has been provided by the fintech companies?
Yeah, so we'll go first. Mr. Pawaskar, over to you.
Oh, okay. Thank you. Thank you so much for that. So the way uh, these controls, to have a better control on how your AI chatbots and other AI applications are using your data principles data is to have certain controls over it. So there are mechanisms where you have increased level of controls on what data is going to be used and what's the purpose of that use, right? So analysis is one purpose, identification is another purpose, right? And then based on identification, you carry out other tasks. Uh, Most of the time, you would realize that not more than one or two elements of those data are required. But very often, the systems are designed in such a way that entire bunch of data is passed on to those systems. So those better controls are very important. That you identify what is the usage and how much of data is being shared, and then what happens to that data. Other controls are available like data masking, data randomization, data tokenization, where mobile numbers can be jumbled up, right? Or any other data can be masked or tokenized when the data is shared. So various controls are available today, and Systech is offering these solutions to most of the fintech organizations so that they can implement those controls and have better control. Then there are other aspects to have data walls, centralized access points, and custom access points for some of those entities where you're centrally running the queries, and the analysis is then passed on to these entities rather than actual data. Those are some of the areas. What do you?
Yeah, so Kushagra, to your question, so I'll like to answer it in two parts. So first, from the data privacy or the DPDP standard. So if you see, suppose I, as a fintech entity, so I am having my own chatbot. Or for that example, I am a bank. I'm having my own chatbot. So obviously, I am taking the data from the data principles, so I'm becoming data fiduciary. And at the same time, if I'm processing the data and putting in chatbots, and also I become data processor also. So at times that's one scenario. The second scenario is that I take data from data principles, I become data fiduciary, and I give it to a third party for the chatbot purpose, and they become the data processors. So how am I kind of safeguarding myself or my organization from both those aspects? I've already alluded my answer in the previous response, but that is one area from DPDP perspective that becomes extremely important. The second part is with respect to the safeguards and the guardrails around the chatbots. First and foremost thing, obviously, you need to have an understanding that when you talk about like something called role-based access control and all. So in our terminology, in our company called RBAC. So whether you have the right person using the right persons are having the right control. So that becomes extremely important. Second, obviously, is your encryption-based models and all. What kind of encryption-based models you have? That becomes extremely important when using chatbots. So it should not be something like which is kind of compromising the information which is there, what you have received from data principles. So you should be having a clear understanding about that. The third part is basically on the policy formulations and all those kind of infosec or information policies we use, or the standards or kind of platforms you use, be the HTTPS, be the SQLs, or be the VPN network what you use. So that becomes extremely important in terms of safeguarding your chatbot. And what kind of review and monitoring what you have. Uh, what are the kind of anomalies what you may find in a particular chatbot, whether someone is trying to kind of break it using some sort of AI or some kind of a formation which is compromising the data of people. So on and so forth. So there are two ways to look at it. One is what kind of mechanisms we are using it, what kind of role play, what we are doing it, so as to safeguard at the very beginning. And what are the proactive measures you are taking if there is something, a chatbot is getting compromised or there are some challenges? So I think organizations need to be prepared for that, to face all those things, be at the initial level or be it happening once that is compromised. And obviously, as far as data privacy and the DPDP Act is concerned, they need to understand whether they are having their own chatbot. That means they are becoming a data fiduciary and data processor at the same time, or they are using any third party, so that they are passing on that liability to the data processor with through proper contracts, arrangements, and MSS. So yeah, that will be my takeaway or my thoughts on that. Yeah.
Thank you so much, sir. That was very informative, especially Mr. Pawaskar's take on the techniques of tokenization, masking of personal data, and Mr. Roychowdhury's take on the encryption of data from the very inception. So at both levels, that is at the transit level and at the rest level. So that was very insightful. Now, as this webinar draws to a close, I would like to extend a vote of thanks to all our distinguished speakers for sharing their valuable insights and to everyone who joined us today. We've covered a wide range of critical issues from the implications of the DPDP Act on the fintech sector to the challenges and the opportunities it presents for data protection, cybersecurity, and compliance. As we move forward, it's clear that while the journey towards robust data privacy and security in fintech is complex, the DPDP Act provides a solid framework for companies to navigate these challenges. To all the fintech professionals and businesses in attendance, remember that while compliance with data protection laws can be demanding, it's an essential investment in building trust and ensuring the long-term success of your business in an increasingly digital world. We hope today's discussion has provided you with valuable takeaways and actionable insights to guide your strategies moving forward. Thank you once again for participating, and we look forward to continuing this important conversation. Have a great day ahead. Thank you.
Thank you, Kushag.
Thank you. Thank you.
Thank
Thank
you.
you, everyone.
Thank you.
Thanks.
Thank you, sir. Thank you.
Have a
Thank you.
great